That's right, but going back
Do you play inside in the winter?
I do, but again in raw. And if I know you're in town, I'm sure when I
You're better off with a Friday.
I think that's a good move, right? Give me a how about tomorrow night?
Tomorrow night I'm booked up.
You're booked up. Okay, that's the way to go.
I am saying over there. I could try that.
Yeah, that's true though. I tell you, second marriage is a good thing. I mean, I guess you know that. Oh,
What's your boy doing?
They're in college. Hamilton. Yeah.
That's what we try to be, Don. You and I. Well, I'm going to talk about federal and how we're overwhelmed.
It was in the Times.
He does? Mike, exactly what is, and I'll put you on the spot, 30 seconds. Tell me something about the Federalist Society.
It's a group of judges and lawyers who basically believe in limited government, careful separation of governmental powers, pro-freedom. To protect freedom, we've got to be mindful of government, especially nowadays.
Would you describe it as a conservative group, a liberal group politically? Is there any swing, politically either way?
I think most of our members would describe themselves as either libertarian, pro-freedom, or conservative. Actually, if you're a student of history, you might say they're classically liberal, because classic liberalism is pro-individual freedom, limited government, limited powers of the monarch or the ruler to tell you what to do, when to do, who to see, what to read. These concepts we have problems with. We want to see individual freedom, and as contrasted with government control of our lives.
You've had a number of very prominent people speak to your group. What do they include?
Well, we've had some very, very powerful judges, fellows who are on the United States Circuit Court of Appeals around the country, and that is, as some of your viewers might know, one level immediately below the United States Supreme Court. Very, very powerful judges. Judge Winter, Judge Kaczynski. Judge Kaczynski is the youngest Federal Circuit Court judge of this century, and he was our speaker 2 events ago. William Bradford Reynolds, Assistant United States Attorney, He's frequently in the news, and he was one of our speakers today. Judge Minor, who is, you hear rumors about the Supreme Court as far as the judge is concerned. So this is the kind of quality speaker I think we're attracting.
The Chief Justice has spoken to you, as has Justice Scalia.
I think, well, Justice Scalia, that's right, he's now Mr. Justice as of last night. This is right. Justice Scalia, I know, was involved in the Federalist Society for a while. We're very pleased about that. Chief Justice, Mr. Chief Justice Rehnquist has worked with us a little bit. We're really pleased with the reception we're getting in today's intellectual climate. I think people are realizing that in order to protect freedom, one of the things you have to do is be mindful of government. Look at what government is doing, and let's keep our eyes on that.
Is this a necessary... let me ask you about the rumors.
But
in the invitation that went out, you said something about Judge Minor is an entertaining speaker and is mentioned as a possible candidate for the next Supreme Court. In your view, or the view of the New York chapter of the Federalist Society, how accurate is it?
Well, we don't know. I mean, these are just what one hears. It's scuttlebutt. I mean, one hears rumors.
What type of pipeline does the Federalist Society or yourself have?
If I were to assemble 100 of the members right now, we asked them what type of pipeline, we'd get 100 different pipelines. And, you know, you hear rumors. People hear they have different sources. They have friends, and who knows where they get it from. But this is what one hears nowadays. I have no knowledge one way or the other.
So, what have you heard? What is the rumor? I don't mean to put words in there.
All right, and I'll give you my best answer.
In your circles, what have you heard about the possibility that Roger Minor may be in the? I've heard the top three.
Well, I have heard that a number of judges are being considered if a slot should open. And among the judges who are being considered, we've heard that Judge Minor is definitely one of them. This is as far as it goes. One really is not able to zero in on these things. Not like a bullseye where you can bang, this is it. Can't do it. Just can't do it.
But you have heard those rumors?
Yeah, this is what I've heard. No question.
Terrible thing. Are the Mets going to win the World Series?
I hope so. I caught the last 2 outs last night. Did you see how nervous Gooden seemed to look?
Just saw the locker scene this morning in early morning news. How strong are the rumors?
I don't know. I mean, you hear rumors, and I don't know how strongly. I really don't. And you won't catch me. I'm too good a lawyer for you to catch me gazing into a crystal ball. Because if I did that for you, you'd fire me if I was your lawyer. So I won't do it. First, let me welcome you. Quite a lot of new faces, which pleases me very much. My name is Mike Weinberger. If there's anyone I haven't met, I'd like to meet you. Let me introduce the board of directors with whom I have the pleasure of serving. Tom Bell, Dennis Jacobs, Kai Alberg, and Mike Rossman, I think, is working on a brief. Duty's call. Let me just give a 30-second report to some of the familiar faces and some of you who have never been here before on what's happening this year and what we're about. We're making some very, very nice progress, starting off with quite a small membership in the past year or two. We've now grown to a membership and mailing list of between 200 to 300, I think closer to 300, and I think we probably had a good 30 or 40 or 50 names tonight. And we're Roger Minor. As you know, the judge is from upstate New York. Some things about his background. He graduated law school at the age of 21, which was, when I heard it, quite remarkable. It really stunned me. He was in private practice for quite a few years, served with the armed forces in Korea. Then the judge was a district attorney, Columbia County, upstate New York. From there, he moved on to the New York State bench, and then from there, he was appointed by President Reagan to the federal Northern District Court, upstate New York. Was there for a little bit of a while, and within the past few years, to the United States Second Circuit Court of Appeals. I know that the topic that he's going to speak on tonight is something that he's truly interested in. I mean, this is a speech that the judge has given quite a lot of thought to, and I think you'll find it entertaining. Judge Minor.
President Weinberger, officers, members, and guests of the Federalist Society, brothers and sisters of the bench and bar, ladies and gentlemen, I appreciate the introduction. It's much better than the one given by my bailiff when I served on the district court. When I entered the courtroom in those days, it was his custom to announce my name and then say, "God save the United States." In accordance with our prior agreement regarding my introduction, I herewith declare that Mike Weinberger is a great lawyer, an expert in products liability, and the author of a 2-volume work in the area of his expertise.
Where's my wallet?
The volumes are available wherever law books are sold or from the publisher. Is that, did I get it right?
We'll talk about it.
All right. A fair exchange. Actually, Mike is a true Federalist. He's got some pretty definite ideas about how the government should be run. For example, he told me that the president should immediately initiate talks with the people who pose the greatest threat to the peace and security of the United States, the Russians and the Congress. Seriously, Mike is a dear friend. I've been following his career since yesterday. He's dedicated to the proposition, any proposition. But he is a great lawyer. From my own experience, I know that he can examine any contract and tell at once whether it's oral or written. I do want to say that some of the society's advertising for this lecture has caused me some embarrassment, especially among my colleagues. I am reminded of the knight who returned to the castle late one afternoon and was met at the drawbridge by his king. The knight was battered and bloody, suit of armor was in disarray, and his horse was emaciated. "Where have you been, Sir Knight?" said the king. "I have been fighting your enemies in the north, my lord, looting, pillaging, and burning," said the knight. "But I have no enemies in the north," said the king. The knight was silent a while and said, "You have now." One of the members of the society told me earlier that there is a fundamental difference between the Russian Constitution and the American Constitution. He said that the Russian Constitution guarantees freedom of speech, but the American Constitution guarantees freedom after speech. And with that distinction in mind, I turn to my prepared remarks. The forthcoming celebration of the bicentennial of the framing of the United States Constitution provides us all with a special opportunity to re-examine our national charter and the unique federal system it established. An important debate concerning the need to refer to the intent of the framers in interpreting the Constitution already is underway. That there should be a debate over this issue seems curious to me, since judges and lawyers always begin their analysis of any document with an inquiry into the intention of the parties. It would seem especially important that they do so with a document as significant as the Constitution. Tonight, however, I open the discussion on a different front, hoping perhaps to trigger another debate. I begin with the proposition that the enlarged criminal jurisdiction of the federal courts has led to an increasing federalization of the criminal law. Whether that proposition invokes a challenge to the system of dual sovereignty established by the framers of our Constitution is the question I propose for debate. The discussion should be of particular interest to those concerned with maintaining the traditional functions of the states and the vitality of the 10th Amendment. Historically, of course, the detection, apprehension, prosecution, and punishment of those accused of antisocial conduct have been considered state functions of the most basic kind. As I see it, the growing use of the federal courts for criminal prosecutions is attributable to three factors: opposing or ongoing, ongoing congressional interest in the development of new criminal legislation, expansive interpretation of federal criminal statutes by the courts, and the demands of state and local governments for federal assistance in criminal law enforcement. Add to these factors the vigor of some federal prosecutors in filling the gaps perceived to exist in state prosecutions, and we have the makings of a glut that threatens to overwhelm the federal courts, courts that were designed to handle a limited number of crimes affecting national interests. The restricted role intended for the federal government in regard to the exercise of criminal jurisdiction is apparent from a reading of the Constitution itself. Jurisdiction over criminal matters is referred to specifically in the Constitution only in 4 of the enumerated powers of Congress: the power to provide punishment for counterfeiting securities and coin, the power to punish piracies and felonies committed on the high seas and offenses against the law of nations, the power to exercise jurisdiction at the seat of government and in federal enclaves, and the power to punish treason. Obviously, the framers expected that general criminal jurisdiction would remain with the states. James Madison put it this way in number 45 of the Federalist Papers: "The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. The former will be exercised principally on external objects, as war, peace, negotiation, and foreign commerce, with which last the power of taxation will for the most part be connected. The powers reserved to the several states will extend to all the objects which in the ordinary course of affairs concern the lives, liberties, and properties of the people and the internal order, improvement, and prosperity of the state." Despite the limitations envisioned by Madison, the Constitution delegates to Congress a number of broad-ranging enumerated powers dealing with various matters of domestic concern. The Constitution also confers upon Congress the power to enact laws necessary and proper for the execution of all other powers vested in the officers, departments, and government of the United States. The authority to adopt criminal legislation is derived from these provisions in our national charter. For example, the first criminal statute enacted by the first Congress in 1789 defined certain customs offenses and was based on the enumerated power to lay and collect taxes, duties, imports, and excises. The Crimes Act of 1790, the earliest federal criminal code, established penalties for 4 categories of prohibited activities within the exclusive jurisdiction of the federal government: felonies committed on the high seas, offenses directly affecting the operations of government, crimes committed within federal enclaves, and interference with the functioning of the federal courts. The offenses sanctioned in the Crimes Act either were mentioned specifically in the Constitution or established under the authority of the Necessary and Proper Clause. The Judiciary Act of 1789 divided jurisdiction for the trial of crimes against the United States between the district courts and the circuit courts. As originally constituted, the circuit courts consisted of 1 district judge and 2 Supreme Court justices, and had both trial and appellate jurisdiction. The act conferred upon the United States district courts a jurisdiction over all crimes and offenses cognizable under the authority of the United States, committed within their respective districts or upon the high seas, where no other punishment than whipping not exceeding 30 stripes, a higher fine than $100, or a term of imprisonment not exceeding 6 months is to be inflicted. I don't know about the provision regarding whipping, but I see some of my colleagues nodding their heads and maybe saying they would like to have that jurisdiction now. Jurisdiction over crimes calling for greater punishments, of course, were vested in the circuit courts. The very limited jurisdiction of the district courts was the cause of some inefficiency in the early criminal justice system. The minutes of the Supreme Court dated February 8, 1791 include a copy of a letter from James Duane, first judge of the District of New York, to Chief Justice John Jay, Duane advised that he had committed to custody one Gorham, master of the sloop Hiram, for breach of revenue laws aggravated by perjury, and one Seeley, mate aboard the same vessel, for landing a cargo of coffee at night without reporting. Noting that he was without jurisdiction to try these offenses by reason of the extent of punishment involved, Judge Duane requested that a circuit court be convened in New York, and it was so ordered by the Supreme Court. It was not until 1891 that the circuit courts became circuit courts of appeals, exercising appellate jurisdiction only. Now, of course, the district courts have original jurisdiction of all offenses against the laws of the United States. Some lawyers describe the present-day courts of appeals as courts for the correction of district courts' errors and for the perpetuation of their own. District judges compare circuit judges. My old chief judge in the Northern District used to say this, that circuit judges were like soldiers who come onto the battlefield after the battle is over and shoot the wounded. One of my district judge friends swears that he once read an appeals court decision opinion containing these words, "We reverse, substantially for the reasons stated in the decision of the court below." You had one of those. A significant expansion of the criminal jurisdiction of the federal courts to cover crimes traditionally punished under state law came about in the Reconstruction period following the Civil War. Until that time, federal criminal law generally was restricted to conduct directly affecting the functions and operations of the national government. The original mail fraud statute, enacted in 1872 as part of a legislative package dealing with the post office, was remarkable as an extension of federal authority into an area formerly thought to be of state concern only. To be sure, the statute was enacted in furtherance of the constitutional power of Congress to establish post offices and post roads, and despite several amendments over the years, proof of its violation still requires a showing of use of the mails to establish jurisdiction. The jurisdictional requirement has become attenuated, however, by virtue of the Supreme Court decision holding that the requirement is fulfilled if the use of the mails can be reasonably foreseen in connection with the scheme to defraud. Court decisions defining the scope of the fraudulent conduct proscribed also have extended the reach of mail fraud prosecutions. Originally designed to prevent the misuse of the postal system, the mail fraud statute has evolved by judicial interpretation into a vehicle for the prosecution of an almost unlimited number of offenses bearing very little connection to the mails and ordinarily prosecuted in the state courts. Cases involving official corruption on the state and local level have been introduced into the federal courts under the umbrella of mail fraud, with the courts finding actionable fraud where the corrupt officials can be said to have deprived the citizenry of intangible rights to their honest, loyal, and faithful services. Ironically, this theory of breach of fiduciary duty was found its expression in a case in which the court said, quote, "We are cognizant of the problem of the ever-expanding use of the mail fraud statute to reach activities that heretofore were considered within the exclusive domain of state regulation. In recent years, the courts have sustained mail fraud convictions of a local political leader whose special relationship with the local government was considered sufficient to impose a public duty upon him, of an employee said to have breached a duty to disclose material information to his employer, of a corporate officer for diversion of corporate funds to unknown purposes, and of an attorney for fraud generated by a conflict of interest. A similarly broad range of activity is encompassed by the wire fraud statute, the twin of the mail fraud provision. Under that statute, the conviction of a man who established a bogus talent agency for the purpose of meeting and seducing young women was affirmed. Chief Justice Berger has written that when a new fraud develops, as constantly happens, the mail fraud statute becomes a stopgap device to deal on a temporary basis with the new phenomenon until particularized federal legislation can be developed and passed to deal directly with the evil. To my mind, that statement raises three important issues: whether there is a need for proliferation of criminal statutes to deal with matters already covered under the mail fraud heading, whether the expanded interpretation of mail fraud implicates the Sixth Amendment right to be informed of the nature and cause of the accusation, and most important, whether there is a place for state criminal law in the formulation of responses to new varieties of fraud. As a fount of federal criminal jurisdiction, the power of Congress to establish the post office pales into insignificance in comparison with its power to regulate commerce among the several states. At the turn of the century, Congress found the need to respond to problems the states could not resolve and began to enact criminal legislation to fulfill that need under the guise of protecting the channels of interstate commerce. The Lottery Act, prohibiting the transportation of lottery tickets in interstate commerce, and the Mann Act, prohibiting the movement of women across state lines for prostitution, were early examples of such laws. In upholding the constitutionality of these two acts, the Supreme Court rejected 10th Amendment violation arguments, as well as contentions that the commerce power was not broad enough to support the legislation. Thus reinforced by the Supreme Court, Congress pushed on to adopt new criminal statutes purportedly protective of interstate commerce channels, supposedly responsive to problems unreachable by state law, and always intrusive into areas previously of exclusive state concern: transportation of stolen vehicles, kidnapping, flight to avoid prosecution, theft from interstate commerce. When the Supreme Court upheld the authority of Congress under the Commerce Clause to regulate intrastate activity affecting interstate commerce, the stage was set for the most expansive intervention of the federal government in crime control since the beginning of the Republic. And this extremely broad interpretation of the commerce power has enabled Congress to provide for the prosecution of local racketeering under the Hobbs Act, which punishes those who affect commerce by robbery or extortion, the Travel Act, which prohibits interstate travel to promote various forms of unlawful activity, the Extortionate Credit Transaction Act, which outlaws extortionate credit transactions or loan sharking, and in recent years, the all-purpose Racketeer-Influenced and Corrupt Organizations Act. Whether the Constitution permitted the enactment of the federal loan shark statute was the issue before the Supreme Court in Perez against the United States. In my opinion, the court's affirmative answer to that question marked an astounding change in the concept of federal criminal jurisdictions and organized crime. Justice Stewart's dissent, and he was the only dissenter in Perez, however, seems compelling. He wrote, "It is not enough to say that loan sharking is a national problem, for all crime is a national problem. It is not enough to say that some loan sharking has interstate characteristics, for any crime may have an interstate setting. And the circumstance that loan sharking has an adverse impact on interstate business is not a distinguishing attribute, for interstate business suffers from almost all criminal activity, be it shoplifting or violence in the streets." Despite the Stewart dissent, it now seems certain that a congressional declaration that a particular activity affects commerce is sufficient to invoke the interstate commerce power as the basis for federal criminal jurisdiction and federal criminal legislation. Such a declaration is included in the Drug Abuse Prevention and Control Act of 1970, where Congress made the finding that federal control of the intrastate incidence of the traffic in controlled substances is essential to the effective control of the interstate incidence of such traffic. Having thus generated its own jurisdictional base, the statute goes on to authorize, among other things, federal prosecution of the otherwise local crimes of possession, distribution, and manufacture of narcotics and dangerous drugs. Thus it is that local trafficking in controlled substances, as well as local fraud, loan sharking, theft, racketeering, municipal corruption, and all other crimes involving matters primarily of local concern, have become grist for the federal prosecutor's mill. As I see it, the ongoing federalization of the criminal law has brought with it some very significant constitutional and pragmatic problems. The problems are these: unrealistic expectations. In 1985, a total of 39,500 criminal cases were filed in the 94 United States district courts. During the same period, more than 51,000 criminal cases were filed in the superior courts of the New York State court system alone. The criminal court of the city of New York is said to handle 280,000 misdemeanor cases each year. Last year, there were 55,000 narcotics arrests in New York City. Nationwide, for the same period, there were but 5,623 marijuana, controlled substance, and narcotics cases filed for consideration by the 575 United States district judges. Between 1984 and 1985, the United States District Court for the Southern District of New York sustained an increase in its total criminal caseload of 51.5%, from 695 to 1,053 cases. Is it realistic to expect that the federal courts in New York City can shoulder 10% of the city's drug cases as suggested by the state administrative judge? Does it make sense to designate state prosecutors as federal prosecutors for this purpose as proposed? From whence are to come the necessary court facilities and personnel? It simply is unrealistic to expect that the federal courts ever will be able to make the slightest inroads in handling the cases arising out of the tens of thousands of narcotics and other crimes committed in the nation each year. Diversion of scarce federal resources. This problem was delineated in a decision of my court in a narcotics distribution case we heard last year. As a member of the panel issuing that decision, I was privileged to concur in an opinion of a colleague who wrote as follows: though the case was developed by New York City police officers, concerns readily visible criminal conduct requiring no special investigatory resources or equipment, and involves a $30 transaction, the matter became the subject of a federal criminal prosecution because it occurred on Federal Day, the day of the week when federal law enforcement authorities have decided to convert garden variety state law drug offenses into federal offenses. Though we are urged in other contexts to tolerate missed deadlines because of the enormous burdens placed upon limited numbers of federal law enforcement personnel, on Federal Day there are apparently enough federal prosecutors available with sufficient time to devote to $30 drug cases that have been developed solely by state law enforcement officers. Be that as it may, the case is lawfully within the jurisdiction of the federal courts and must be decided. Then we went on to affirm the conviction. The obvious question presented by the decision is this: should the federal courts be used for the prosecution of $30 buy and bust cases? I suggest that it might be a better use of resources to reserve federal courts for the prosecution of major interstate and international trafficking in those pernicious substances that have become a modern-day plague in our nation. The same considerations should apply to other crimes as well. Federal prosecution should be limited to misconduct affecting clearly defined national interests. Duplication of effort in law enforcement. It seems inevitable that problems will arise when state and local prosecutors have the authority to prosecute the same acts as violations of both state and federal law. Sometimes there are unseemly turf wars, as was seen recently in New York City in connection with investigations into allegations of municipal corruption. Sometimes, of course, there are clashes over who should be prosecuting crimes in mutual jurisdiction situations, as demonstrated in regard to drug prosecutions in this city. Always there is the specter of duplication, waste, and destructive competition for the taxpayer's law enforcement dollar. Although there is no constitutional bar to punishing a person twice for one act offensive to both federal and state sovereigns, is it necessary? Is it efficient? I suggest that the public interest is not well served by duplication of effort in law enforcement. Unbridled discretion of federal prosecutors. As Congress defines ever more crimes, it becomes inevitable that federal prosecutors gain ever more discretion to decide what crimes they will prosecute. This is so because the expansion of federal law enforcement agencies, prosecutors, and courts cannot keep pace with the proliferation of federal crimes. Federal district attorneys, therefore, must become very selective as to the crimes they will prosecute and those they will decline to prosecute. These appointed officials thus acquire the greatest power in the law enforcement field, because to them is entrusted the authority to decide which cases they will bring to court and which they will not. An attorney recently told me of the great effort he was making to persuade a United States attorney not to prosecute his client for a state sales tax violation. The prosecution was threatened under the mail fraud statute, of course. My impression was that the case would be won or lost on the question of exercise of discretion. Where there are many criminal violations, but only a few can be chosen for prosecution, the prosecutor invades the province of the lawmaker. There is then a public perception that the process is unfair. Loss of the capacity for self-government. The citizenry increasingly has been conditioned to turn to federal law enforcement and to the federal courts as the first line of defense against antisocial conduct. What we are witnessing is an abdication of responsibility for self-government, reflected in the attitudes and lack of accountability of those chosen to govern on the state and local level. In the face of municipal corruption, it is easy to send for the federals. If narcotics are sold on the street corners of a major city, it is a simple matter to invoke high-profile federal criminal prosecution. When loan sharks and racketeers infest the municipality, local law enforcement efforts can be relaxed if federal help is on the way. But something is lost in the process. The traditions of democratic self-government and of individual involvement and neighborly concern that have been the hallmarks of our society. To invite federal authorities to define and prosecute crime involving activities primarily of state and local interest is to concede that state and local government cannot be moved to serve the will of the people. I do not believe that the American people are prepared to make that concession. Before there is a complete merger of state and federal criminal law, the following steps might be considered. First, Congress should undertake a study of each and every criminal statute, identifying those dealing with matters of true national interest and discarding all others. Second, no new federal criminal legislation should be enacted without assessing the impact of the legislation on federal courts and other federal resources. Third, consideration should be given to conferring upon state courts jurisdiction over federal crimes. This is not a new concept. It has its roots in the early days of our judicial system. Fourth, the Department of Justice should develop, enforce, and widely disseminate precise guidelines circumscribing the exercise of discretion by United States attorneys. These guidelines should proscribe duplication of state prosecution. Fifth, mail fraud and other criminal statutes given expansive interpretation by the courts because of imprecise statutory language should be studied with a view toward adopting more specific descriptions of the conduct prohibited. And sixth, the excellent program introduced by the Department of Justice to promote cooperation and coordination among local, state, and federal law enforcement agencies should be expanded and encouraged. The criminal law is but one area where Congress has intruded into and displaced the functions of the states. But it is the duty of Congress, just as much as it is the duty of the judicial and executive branches, to maintain that deliberately measured allocation of authority between the states and the federal government provided by the Constitution. Given the underdeveloped capacity of Congress for self-restraint, to use a phrase coined by Justice O'Connor, there may be some doubt whether the legislative branch has any great enthusiasm for that duty. Chief Justice Marshall wrote that the power of Congress under the Commerce Clause is restrained by the wisdom and the discretion of Congress, their identity with the people, and the influence which their constituents possess at election. The same factors are implicated in the exercise of criminal jurisdiction under the Commerce Clause and in the whole issue of the state-federal criminal law dichotomy. Of these factors, the most important is the influence of the electorate, because in this democratic society, the proper direction of our federal system can be determined only by the people. Thank you.
The flyer said an entertaining speaker. Just, you heard it here first. Judge, thank you. Fabulous. Little announcement, then we're going to take some questions and answers. Well, actually, I'll wait with the announcement. Judge, would you like to take some questions and answers now? Okay, questions? Throw them to the floor.
I can't answer that. Yes.
It seems to me that the solution that you're proposing about the electorate being more concerned is the problem. Primarily, the electorate is fed up with the idea that people actually can go to trial and might have to be proved in court guilty with evidence. And therefore, the national candidates say it's the federal responsibility to solve the problem of crime. Every presidential candidate said, everybody says, we could solve crime if we don't get involved. And so they keep passing on to the federal government with the consent and chorus of the public rather than the other way around.
Well, I think that's an important point that you're making, that because you're talking about public apathy. And of course, the question is, how mad do the people have to get to take back the government? And I think maybe that by increasing the federal power, continuing to increase the federal power, there is no incentive for people on the local level and the state level to say, well, we're going to take over the government and we're going to demand that law enforcement be done in a certain way, and we're going to be responsible for our own fate and our own future. That was the concept, certainly, when the Constitution was written. James Madison will be some surprised to see what has happened here. But we'll try to straighten it out before he comes back. Anybody else? Yes?
Four Chinese in the flea market who had imitated the famous doll were subject to a seizure order by the federal court. And I got into the case on a volunteer basis and represented these four Chinese. What astonished me when I read the document prepared by patent and copyright lawyers, and I'm a registered patent attorney myself, so then when I read that document, I was so amazed to see the enlargement of the RICO statute applicable to these four Chinese. Of course, I settled that case by
You took one look at the RICO statute and decided better to settle. Is that it?
That's right.
Yeah.
It's
Good
so
judgment.
submerged, those poor Chinese, I couldn't envision how they could apply the RICO statute and how it could stand up in the courts of law, at the district level, and in the appellate courts. What do you think?
Well, the RICO statute is just one example. I mentioned it during my remarks of the expansion of federal jurisdiction. You have prosecution of racketeers and so forth on the federal level, when it could also be done on the state level. And the Interstate Commerce Clause, of course, constitutionally authorizes that type of activity. So you ask what they do on the district court level and maybe on the appellate circuit court level, we look to the U.S. Supreme Court, and they tell us where we go. And they've said that the power of Congress in this area is almost unlimited. And so we have to look someplace else. It's a question of courts deferring to Congress. And many times people say the courts don't show enough deference to Congress. The courts make the laws and so forth. Here the Supreme Court...
Possibly there are too many laws of all sorts, and not merely criminal laws?
Some years ago when I had a case before me in the state Supreme Court involved prison visitation or something, I cited I think an article from Newsweek or Time or something, a very good, important scholarly judicial piece. And the title of the article was "Too Much Law?" ? And that was 10 years ago. There's been a lot more law enacted since. And I haven't even, in the course of my prepared remarks, because our president here told me to keep it down, I never got to the Comprehensive Crime Control Act of 1984, in which the whole thing was further expanded, including damage to a fuel facility and bribes by an agent of an organization receiving federal funds, and an interesting one, counterfeiting credit cards and computer crimes, and one that I like very much in the 84 Act, stealing property of another which has a value of $10,000 or more in connection with the marketing of livestock. in interstate or foreign commerce. Now, they're still adding laws all the time. And if you look to see what they're doing, the President and the Congress have some more laws to propose in connection with drug abuse and control. So we're finding the proliferation of criminal laws continuing to this very time. And nobody seems to be getting too panicky about it except me. And my colleagues who are on the panel are talking about the $30 drug bust. Yes?
Judge Minor, you've referred to the possibility that there may be aspects of federal criminal jurisdiction that could be handled by the state courts. Do you have any particular ideas on that, and where would they get the resources?
Well, I suppose that the resources are finite. You only have so much in the way of resource. What I'm saying, I think, is that maybe the resources, there are more resources available on the state level. The statistics I gave you seem to indicate that the federal courts are just about saturated. So if you take some of this, is an old proposition, early days of the Republic, the Congress conferred some jurisdiction upon state courts to hear various federal crimes. There always will be a competition for the resources. The question is, where should it go? And I think maybe we should stop now and look at the federal system and say, it just isn't there. We can't handle, unless we want to double the size of the federal courts and greatly increase federal law enforcement personnel and so forth, we can't do it. I think maybe a little bit of overflow in the state courts wouldn't hurt. The state judges will tell you, and a couple of my former colleagues from the state court are here, they'll tell you they're overburdened as it is now. Believe me, they don't do anything like a federal judge. I'm sorry, fellas. But the point of it is that that you can't. We talk about diversity of jurisdiction on the civil side, and making more room in the courts, in the federal courts, by divesting diversity, or at least increasing the dollar amount, the amount in controversy, so we can get rid of some of the civil cases we have. When I was a district court judge, I tried a case of a dog bite. You see. Up north, and there was a dog bite case, and I was trying to find whether there was diverse jurisdiction because the dog was from another state, or how they got into federal court. I had a case of a woman who fell off a horse. I have all kinds of cases there that probably would have been better off in the state court and free us up for some of the federal statutory things that we have to concern ourselves with. But we can't persuade, and so far we've been unable to persuade our state court colleagues to take on some of our cases, and as a matter of fact, what we're doing now, from what I read in the papers, the Southern District is considering taking some of the cases from the state courts. And the present Chief Judge of the Southern District is considering that. The future Chief Judge is here, and maybe he'll have a different view of that. But this is a problem that we're facing, and sure, there's a competition for resources, but there are only 575 federal judges on the district court level with original criminal jurisdiction in the whole country. It's foolish to think that they can make anything but the slightest dent in criminal matters. There are so many federal criminal statutes on the books, I think that if they prosecuted each one once, they wouldn't be able to make it around for a year.
Judge Minor, with regard to your cogent arguments about the expansion of federal criminal jurisdiction, how can we look with optimism towards congressional self-restraint, especially in an election year when a notable federal prosecutor and indeed a senator have decided to play Miami Vice in Harlem?